except in the case of a split, a legislature has to report his party willy-nilly.
Mr. Sibal, the only problem is, I just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote, because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in the... Which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue. The government has to continue. It's basically reduced to a complete minority, probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaz. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose confidence of the House, Malaz? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Narasimha Rao ran the minority government. It's not as if governments can't be run by minorities. Is they don't want to lose the membership of the House. It's a double whammy, Malaz. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister. You become a chief minister. Use the governor's office for that. Your Lordship, Malaz, I don't have to say anything more. My political experience and your judicial experience, Malaz. We have reduced ourselves to, we are mocked. People don't believe us anymore. Anyway, so...
Now we go on to Shivraj Singh.
Then Malaz Shivraj. Respondents relied on the law in Shivraj to contend that where the governor has reason to believe that the incumbent government does not possess the support of the majority, the correct course of action would be for the governor to call upon the chief minister to face the assembly and to establish the majority of the incumbent government within the shortest possible time, irrespective of the fact of disqualification. Well, I'll just read the highlighted portion. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. As I read the beginning, as a matter of constitutional law, it would not be correct to proceed on the basis that the constitutional authority entrusted to the governor to require the council of ministers to prove their majority on the floor of the House can only be exercised on the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called into question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. So we are not against the floor test, we're against the considerations on the basis of which the floor test was ordered. It is respectfully submitted that Shivraj Chauhan, there are no disqualification petitions. Now, this is the other thing, pending against the MLAs whose resignation was under consideration. As noted by the Honorable Court in para 41, notices of disqualification had been issued against 6 MLAs on 13/3, but the Speaker had accepted the resignation of these 6 MLAs on 14/3, which I mentioned to your Lordships yesterday. As regards the other 16 who had tendered their resignations, the Speaker had not yet accepted their resignations. When the Governor directed a floor test to be held, the disqualification petitions were not pending against MLAs whose resignations were under consideration when the floor test was held. On the other hand, in the present case, Governor's decision to direct a floor test to be held on 20, knowing full well that the very MLAs of SHIVSENA Legislative Party who the Governor had recognized are facing disqualification. Furthermore, this Honorable Court's observation in para 80, the pendency of proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test, are premised on the constitutional principle that neither the Court nor the Governor has any right to impinge on the Speaker's power to decide on the issue of disqualification. This Court cannot say that you cannot decide, or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the Court. It is straight law that neither the Governor nor, for that matter, this Court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. Well, that's now 5 judges have said that. Therefore, that order on the 27th put us in a situation, where the elected government was toppled. Neither the Governor nor, for that matter, the Court can entrench upon the power of the Speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue, and there cannot be any Kitemek order. And whereas in the present case, the decision to hold the floor test was taken by the Governor on 28/6, by which time this Honorable Court had already interdicted the disqualification proceedings against the respondents on 27/6. The Governor, being aware of the pendency of the disqualification petitions and being aware of the fact that this Honorable Court had extended the period of filing a reply on 2012, could not have disturbed the status quo in the Assembly by directing a floor test. Para 82 of this Honorable Court noted, nothing prevents the Speaker from taking a decision either on matters of resignation or of disqualification despite convening the trust vote. Even in Shivraj Chauhan, your Lordship said, because there was no interdiction there. So the Court said, in Shivraj Chauhan, the Speaker could easily disqualify. But in this case, what happened? The Speaker could not move. So how does Shivraj Chauhan, an authority for the proposition that a floor test is necessary in these circumstances? Illegality of the Governor's decision on 28/6 cannot be remedied by subsequent event or actions. The respondents have sought to justify the Governor's decision dated so and so by relying on Uddhav Thackeray's resignation on 29/6 instead of facing the floor test. Further, it has been contended that even the votes of 42 MLAs were excluded. We are still through. That's not relevant. When Bomai was decided, and Bomai set aside orders under Article 356, what did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your Lordship. That what Bomai said was the acts that have happened in between can be validated by the court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the Chief Minister Mullahs by setting aside the order of the Governor. So we are not saying, Malaj, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your lordships decide one way or the other. Anyway, Malaj, I'll just quickly now. Then Malaj, kindly come to 46. S.R. Bommai and Union, the court, while considering the legality of a presidential proclamation under 356 that has been subsequently approved by both houses of parliament, held that an invalid proclamation would nevertheless have to be set aside. This argument, that is according to an argument of frustration, because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the house. All irrelevant. Bommai says so. Held that an invalid proclamation would nevertheless have to be set aside, thereby recognizing the principle that the legality of an act must be tested on its own terms, and acts consequent thereto cannot give the color of legality to an action which is illegal. I've given the paragraphs, Mulas. Further, Bommai holds that upon invalidation of the proclamation under 356, the natural consequence is to restore the status quo ante. Court may, however, mold the relief in respect of subsequent acts, but when restoring the status quo ante, the court must restore the Council of Ministers and the Legislative Assembly as they stood on the date of the issuance of the proclamation. Otherwise, the remedy of judicial review would be rendered meaningless. How much more eloquent can the court be on this matter? In fact, Bommai goes on to say that holding of fresh elections can also be injuncted on the principle that such a relief is to prevent the frustration of the constitutional remedy. It further goes on to say that the court may be duty-bound to give an interim order of this nature to make effective the constitutional remedy of judicial review and to prevent the emasculation of the Constitution. Well, what's the point, Millets, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? Additionally, Millets, additionally, it is settled law that the village, let's leave that out, Millets. So, Millets, para 52, the legality of the governor's decision has to be determined with reference to the decision itself, not by reference to any subsequent events or facts. There is no constitutional basis for the proposition that the otherwise illegal decisions of the governor can be justified by referring to subsequent events and actions, including the fact that the petitioner participated in the floor test on the 4th of July. Then governor's decision on 30th of June to swear Eknath Shinde. That's the next. It is respectfully submitted that governor does not have the power to invite a leader of a faction of a legislative party, acting to dehorse the political party. But where does the governor get this power from? Who is he recognizing? Leader of what? Governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the Election Commission. The leader is as communicated to the Election Commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Mullat. In the instant case, it is undisputed that on the 30th of June, Uddhav Thackeray was the leader of the SHIVSENA political party. However, the governor extended an invitation to form the government of Shinde, whose only claim as on 30th June was that he is the leader of the majority faction of the SHIVSENA legislature party. The governor, as on 30th of June, did not and could not have recognized Mr. Shinde as a leader of the SHIVSENA political party. As submitted above, a parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of the legislature. I've already said that. As submitted above, therefore, the governor's action of inviting Shinde Mullats to form a government illegitimately recognized an alliance between a faction and SHIVSENA legislative party and the BJP, which is constitutionally impermissible. The governor's decision is liable to be set aside on this basis. Further, the respondents have failed to deal with the petitioner's reliance on 164(1)(b). Mullats, let's leave that out for the moment. Let's leave out the other things. Then, Mullats, they relied upon Kuldeep Bishnoi. What I have now done is, Mullats, I've given no lordships, para 62, what Kuldeep Bishnoi held and how it's wholly irrelevant, Mullats. So that I don't have to, Mullats, unnecessarily take your lordships. I've put it out in the note itself. And then Shivraj Chauhan. Then come to respondents. Now, this is the next topic. Next topic is page 20. Item C, respondents based on undisputed facts on record have incurred disqualification under 2(1)(a). Petitioners have shown that the undisputed facts of the respondents, namely so-and-so, passing a parallel resolutions. I will let Dr. Singhvi actually deal with this because originally also he had dealt with it. So let's sort of... Then C1, repeated, now respondents contend that now repeatedly saying that there's been a split and you have not merged is of no consequence because there is no one, this is no one's case. I have never argued that I have split from the political party. I'm just quoting from the transcript, how useful this transcript is. I have never argued that I have split from the political party. We have never argued that we needed to merge with other parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we are within the SHIVSENA, represent the rival faction. Now he's accepting it. Representing the rival faction which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he's saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself. What political party? I'm quoting only from the transcript. And has now been recognized as a political party is in question is in this matter. Then, I've said the contentions of the respondents never claimed that they are a faction of the legislature, but they are a political party itself is totally misconceived. After the deletion of para 3, a faction, I've already said that. Effect of deletion is that a faction, as soon as it indulges in prohibitive conduct under para 2, would have no defense available. So they have no defense available. Respondents' justification in substance is that they are the majority faction in the legislature party, which is no justification in the eyes of law. Respondents cannot avoid the inevitable consequence of disqualification. Legality of respondents' actions is to be tested based on substance and actual effect on the impugned acts. I will not deal with it. Now, let's forget about this election commission for the moment. Now come to C3, page 22. Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities. To prevent acts which would amount to disqualification. That's the whole purpose. The Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. In furtherance of their smokescreen defense of being in SHIVSENA, the respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. First he says, I am a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party. That is how it has been right through the whole artificial distinction which has been drawn, that is that the legislature party who did it and the political party had nothing to do with it. I have never ever said that the two are different. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? decision of the legislative party as the authority of the political party, unless he says, my faction is the political party. Thus, in substance, the respondents contend that the faction representing a majority of the legislative party is deemed to be the political party without regard to the political party which has been registered by the Election Commission under 29A. A fortiori, therefore, without referring to the original political party which has been registered with the Election Commission, the majority faction contend that they can hold themselves out as a political party and take actions within the House, dehorse the political party on whose ticket they were elected. It is submitted that a majority faction cannot claim that they are the political party registered with the Election Commission under 29A of the Representation of Peoples Act. There is nothing in law which allows such a claim to be made. Distinction between the legislature party and the political party is reflected in the provisions of the 10th schedule. Submission of Eknath Shinde group is contrary to the clear provisions of paragraph 1 and paragraph 2 and the explanation. I have read it to your lordships, but I will not trouble your lordships with that. Then I only come to para 83, if the respondent's submissions were correct or were to be accepted, it would create chaos within the political system with functions within the scheme of the Constitution as provided for in its various provisions, including the 10th schedule. So, Mullahs, now come to C4. I will leave the rest, Mullahs. Now, Mullahs, your lordships will remember all this happened much before the matter went to the Election Commission, because there they moved on 19th July. Mullahs, all this is so per se unconstitutional. Now come to right to dissent. The respondents have claimed that the 10th schedule cannot be used to stifle dissent within the party, and definitely internal dissent does not amount to voluntarily giving up membership of the party. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution, not in any other context, and was rejected. And 105 of the Constitution, Mullahs, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. Respondents have claimed the 10th schedule cannot be used to stifle dissent. Then at the outset, it is respectfully submitted that the said contention is in complete violation of the decision in Kyoto, where this court specifically considered and rejected the argument that provisions of the 10th schedule violate the freedom of speech and conscience of the legislatures. It was held that people have grown distrustful of the emotive political exultations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. This court is distrustful of that, is what Kyoto says. The 10th schedule, it is urged, negates those very fundamental assumptions of parliamentary democracy, of freedom of speech, of the right of dissent, and the freedom of conscience. This was urged by Mr. Jethmalani. It is urged that this unprincipled political defections may be an evil, but it will be the beginning of much greater evils of the remedies graver than the disease itself were adopted. 10th schedule, they say, seeks to throw away the baby with the bathwater. So, Mullahs, all this I don't have to go through. And then, Mullahs, this went on. I will not trouble your lordships. Kindly come to para 44. Para 44 is what. But a political para, page 27, functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independently of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is its source of sustenance. And then, Mullahs, Mullahs, para 47, Mullahs, this is a quotation from From Rodney Brazier. Once returned to the House of Commons, members' party expects him to be loyal. This is not entirely unfair or improper, for it is the price of the party's label which secured his election. Now, my lords, disloyalty is for a price which has secured him the chief ministership. If I can put it, my lords, differently. Then, my lords, para 49. Well, it's the highlighted portion. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful of the emotive political exaltations that such floor crossing belong to the sacred area of freedom of conscience, or of the right to dissent, or of the intellectual freedom. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation have been the bane of the times. This is recognized by a constitutional court. Above certain theoretical assumptions, which in reality have fallen into a morass of personal and political degradation. And this particular litigation is a shining example of that political degradation. We should, we think, defer to the legislature's wisdom and perception, saying we know the reality, and that's why the 10th schedule, that's why they must not crossing the floor must not be allowed. And then Bomai, whatever may be his personal, I've already, Malads, personal this thing, I've already read that, so I will not trouble you. Then, Malads, now, para, respondents based on undisputed facts on record of incurred disqualification. I will not do that. I let my learned friend deal with it. Malads actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of theirs, which is undisputed. 21B, of course, but that's afterwards. Yes. Then, Malads, now, E is the decision of the Election Commission under para 15 cannot efface the disqualification income. Malads, whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but that's, we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification. That's the purpose of this particular paragraph. So, Malads, I will. Then the order dated 27/6 interdicting proceedings before the Deputy Speaker, in effect, created a hiatus in the operation of the 10th schedule. I've already, Malads, dealt with that, so I won't trouble your lordships with that. And then the list of dates. Then the only thing I have to now, Malads, is to go back on my written submissions. My written submissions. Original written submissions. Yes. Now, Malads, I want your lordships to look at the chapter relating to whip.
In your rejoinder?
No, Malads, my
Originally,
original submissions, yes. Chapter relating to whip, that is PDF page 70 in my written submissions.
70.
Don't mind.
70.
70. Lordships, just have a look at it.
Chapter 7.
Yes.
Chapter 7 on whips. And Malads, they did not address your lordships on this at all. The only thing they gave was that document which I showed to your lordships yesterday.
Only one thing which they have said about
Yes.
whip is
Yes.
that they have referred to the disqualification rules.
Yes. Oh, yes, I have to deal with that.
Perhaps you may want.
I'm sorry, I should. In my
related to 3-1.
I'm going to show that immediately, Malads. That's my mistake. I should have, in my desire to finish quickly, Malads. Kindly go to those disqualification rules. There is compilation, Malads.
Rule you will have to say.
Yes. Statute compilation. This is PDF, Malads, page 6. Thank you, Malads, for reminding me. I should have dealt with it.
We have some doubts, so.
Yeah.
Yes.
Malads, definition of leader. Your ladyship has it, my lord has it?
Yes, we have it.
Leader in relation to a legislature party means a member of the party.
What is he referring to?
He's reading Maharashtra this thing.
तो ठीक है, कोई बात
First bookmark,
Page
page 2,
हाँ, एक बजे कर लो।
rather 4.
516.
Definition.
तुमको भी time मिल जाएगा।
Definition.
Oh, okay.
हाँ।
Yes. Thanks.
So PDF
Yes.
6.
Yes.
6.
See, leader, lordship has that now?
Definition of
Leader in relation to a legislature party means a member of the party chosen by it as its leader. Chosen by the party as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, brothers. And includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, Malad, with all my contentions. This is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. This argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amalas, yesterday, an argument was made, how could they whip act outside the house? Malas, what were they doing in Assam? Appointing a whip outside the house? They made me a serious argument yesterday. This is a whip, how could they do it outside the house? So you're sitting in Assam in the lap of the BJP, and you are displacing a whip which is recognized by the political party and conveyed to the speaker, and these office bearers are there on the record of the register of the assembly. And you say Gugavle is the whip. I mean, it's per se voluntarily giving up membership. You say I continue to be the leader. On what ground? You've been removed on the 21st of June itself. So how are you the leader? Let's kindly look at it this way for a moment. Well, supposing I say I am the party, what should I do? I should go to the party, call a meeting. There are rules of the party. Go and establish your majority in the party, and then become the chief minister. There may be no dispute in the legislature party. Take a case, Malas, where there's no dispute in the legislature party. What would a person do if he says that, look, I am the party? He will go to the party. He can't do it any other way. Now, if you are able to galvanize the support of X number of members, there may be minority, there may be majority. And then on the basis of those numbers, you destabilize an elected government, and then go to the election commission, and on the basis of the fact of those very people who are subject to disqualification, get the symbol and then say, I have the party. Which of the two procedures would be constitutional? Constitutional law, Malad, members of the legislature can never be given primacy over the party. Never be given. Because they are individual members, Malad. Group means you may actually act together. That's not relevant. So, Malad, this is one part that they relied upon. Then para 3.
3 must be read in terms of.
Yes, exactly. I was going to read that, Malad. That's at page 5. The leader of each legislature party, other than a legislative party consisting of only one member, shall within 30 days from the date of commencement of these rules, or where such legislature party is formed after such date within 30 days from the date of its formation, or in either case within such further period as the Speaker may for sufficient cause allow, furnish the following to the Speaker: a statement in writing containing the names of members of such legislature party, together with other particulars regarding such members as in Form 1, and the names and designations of the members of such party who have been authorized by it for communicating with the Speaker for the purposes of these rules. Clearly, Malad.
It is in the definition also.
Yes. Then, Malad, my Lord the Chief Justice asked a question, or one of your lordships asked him a question: is the whip mentioned in the form? And the answer is yes. The fact is, it is not. Kindly see the form now. He gave the answer as yes. Page 13.
Whip is by convention, is it?
Yes, absolutely. It's not even there. Party affiliation, that's all. Item 5. Date of election, date of signing of the form.
Which form is this?
This is Form 1, Malaj.
Form 1. Name of the legislature
That's
party.
all.
Name of the corresponding political party.
Yes. There's no question of whip. No question, Malaj. That's something that's appointed by the party.
Page 5.
Page 11.
Page 11, your ladyship may have. Page 11, Form 1. PDF 13. So, Malaj, it's crystal clear. Which is why, Malaj, they very strategically did not refer to all that I had said about the whip. Not mischievously, strategically. Huh? Yes, Malaj. I was on petitioner's written submissions on this, Malaj. Petitioner's written submissions. I got it. Yeah. That's at PDF, Malaj, page 70.
It's for lunch because we'll relax a little.
Let me see. PDF, Malaj, page 70 of on whips and the role of political parties. So, Malaj, he said there's no distinction between legislature party and political party. See the definition. Subject to provisions of paragraph 4 and 5, a member of a house belonging to any political party.
Where are you reading?
Page PDF 70 in my written submissions.
On whips and the role of political parties.
Yes. Which, Malaj, they didn't deal with it
You
at
have
all.
read in detail, Mr.
I'm sorry?
Well, that one you had read very much in detail.
In fact,
written-
we've highlighted.
Originally, yes.
We've highlighted that.
I highlighted the history, how a whip was, all that I said, but they didn't deal with it at all. Their argument was, no, the legislature party appoints the whip. And they gave that document to your lordship, which is contrary itself to the record, because that's a Rajya Sabha member appointing with it. So, that's, I've done with this part of it. Now, a bit about Nabam Rebia, if your lordships will permit me. As far as Nabam Rebia is concerned, Nabam Rebia does not take into account the ambit of Article 179 of the Constitution and the concept of removal in 179. You see that. First was 179C.
not
be
taking
removed
into
from
account
it.
the concept of removal in Article 170.
Yes, removal in 179C, Malats, not dealt with at all. In that context, yes, kindly have a look. Provided that no, it's like not a no confidence for which no reasons have to be given.
May be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly.
Intention to move. Intention to move. Your Lordships will remember the
Yes.
submissions that I had made. The question of moving doesn't arise. Intention to move. So that concept, Malats, not dealt with in Navam Rebia at all. What does Navam Rebia say on the issue of 10 members, Malats? My learned colleague, Mr. Jethmalani Malats, said that seemed to be an erroneous interpretation. Then members means then who are members of the House at that point in time. That will exclude people who are disqualified. But Navam Rebia says, no, you can't change the status of the House, even if there are disqualifications.